Hello, everyone, and thank you for joining this class. My name is Ana Villalobos, and I'm an agent and coach coordinator of La Rosa Realty in Georgia. I will be sharing my screen. And today we're going to be talking about mastering contracts for the state of Georgia. If you happen to have any questions or doubts, feel free to write a comment on this video, send a message, or send a message to our broker. A little quick housekeeping items, and I guess this will apply for if this class had any people connected. Since we do not have anyone connected, this class will be recorded just for the content. If you are watching this as a pre-recorded webinar, you will be able to ask questions, but you can email directly to me. If your questions has not been answered, my contact will be displayed at the end. So I will share my information. So if you have any questions, feel free to contact myself or our broker in La Rosa Realty, Georgia. Some of the stuff that we are going to be covering today will be number one, parties of the contract, property description, purchase price and escrow breakdown, contract timelines, occupancy and possession, assignability, financing, closing costs, and special assessments such as HOA, etc. So without wasting any time, let's get into this. And like I said, if you have any questions, write them down so you can send them over later. Number one, we have our purchase and sales contract. This is what we called an offer contract. This contract is filled out when you are working with a buyer and you're ready to submit an offer. This is the document that is used to send an offer. The first section that we see here is our title and the date. The date has to be the same as when we write it down, and we have everybody's signatures on there to send over as an offer. This contract has sections, and we're going to be going through each section and explaining each line and understanding what needs to be written down on each section. Again, for each offer, this is different. So obviously the information is going to be different, but this will give you a guidance and an idea of what needs to be filled out. Number one, we see key terms and condition is letter A. And inside this letter, we have a square with numbers. And our first number is the purchase and sales. And it is labeled AB. With the property identification, we write down what we see, the address of the property you are submitting an offer to. This is a section where you would be putting the address, city, county, zip code, etc. The MLS number, how it appears on the MLS, Georgia MLS or FMLS. This is the MLS number. Some people leave it blank. I always fill it out. So I always recommend for you to fill it out. Don't leave it blank. The tax parcel ID number, this ID number is found in the Georgia MLS under CRS tax records. We have to look it up by using the address and extracting the tax parcel ID number. This is a section where we will add this. And excuse me. That's the part where we would be putting that part. Letter B, which is the legal description. This is the legal description of the property, a more detailed description of the property other than the address. This helps identify the property or identify the title for the home by the attorney. We get 4 options. Number 1 being attached as an exhibit here too. If you have a legal description exhibit provided by the seller, you may attach it to here and you would be selecting number 1. You do not have to select all of these. You can select one of them. Number 2, if this is an offer to a condominium, attach F204 condominium resale purchase and sales exhibit. This will have to be filled out as an exhibit and attached to this document to the offer, and you would be selecting number 2. Number 3, if you choose to use the deed book number and the page number, this is a section where you would add it. And this information is found also where you would get the tax parcel ID, and that is again in Georgia MLS under CRS tax records. And it's probably the standard selection, or it's the easiest way to find the description of the property is to get the deed book number and the page number. Number 4 is a much more detailed description of the property by land lots, district, lot, block, unit, section, and everything that describes the property. If you have all of this information, you may add it here and select number 4. Normally in the tax records, you would find most of this information, but sometimes not everything. If you do go and select this section, you must fill each box with that. You can't leave any of the spaces blank. Because of that, this is why we select number 3 as probably the easiest and just more standard to use this selection. So whichever one you have, you would select your legal description here, and then we move over to the description of what is the purchase and sales. And it is A, B, and C, which is warranty, examination, and title insurance. This is what the contract is supported by, meaning that the seller warrants that at the time of closing, seller will convey good and marketable title to said property by limited warranty deed, subject only to zoning, general utility, sewers, and drainage easements of record as of binding agreement date, and upon which the improvements other than any driveway or walkway do not encroach. Declarations of condominiums and declarations of covenants, conditions, and restrictions of record of the binding agreement date. So this is explaining this section right here, which is A and B, and then obviously 1, 2, 3, and 4. And this gives you a little further explanation of what we're filling out. B, which is the examination, buyer may examine title or take survey of the property and furnish seller with a written statement of the title objections or prior to the closing. If seller fails or is unable to satisfy valid title objections at or prior to the closing, or any unilateral extension thereof, which would prevent the seller from conveying good and marketable title to the property, then buyer, among its other remedies, may terminate the agreement without penalty upon written notice to the seller. Good and marketable title as used herein shall mean title which a title insurance company licensed to do business in Georgia will insure and its regular rates, subject only to standard exceptions. And then we get letter C, which is title insurance. Buyer hereby directs any mortgage lender involved in this transaction to quote the cost of the title insurance based upon the presumption that the buyer will be obtaining an enhanced title insurance policy. since such policy affords buyer greater coverage. We move over to number 2, which is the purchase price of the property and the closing cost. In this section, we will be writing down the amount of the offer, meaning the offer price is going to go here. If the house is listed for a certain amount, but the client is, making a different offer, this is the amount that the buyer is going to write down and wants to offer. And then on box number 3, which is closing costs, seller's contribution at closing, this is the amount that the buyer wants the seller to contribute towards the closing cost. And this may vary. This is up to the buyer how much they want as help. It can be 1%, maybe 3%. But either way, it can also be 0, depending on the amount the buyer wants the seller to contribute. This is where we would write down the amount. And again, as we forward to the explanations of these boxes, we see number 2 being purchase price to be paid by buyer. Purchase price shall be paid in US dollars at the closing by wire transfer immediately available funds. So it's just stating that this is in dollar amounts. It needs to be transferred to escrow or title company. And box number 3, which is closing cost, and we have A, B, and C here, which is seller's contribution at closing, items paid by buyer, and prorations. Seller's contribution at closing, seller shall make the reference seller's monetary contribution which buyer may use to pay any cost or expense of the buyer related to the transaction, including without limitation any commission obligation of buyer. Buyer acknowledges that buyer's mortgage lender may not allow the seller's monetary contribution or do the full amount thereof to be used for some cost or expenses. In such event, any unused portion of the seller's monetary contribution shall remain the property of the seller. The seller shall pay the fees and costs of the closing attorney. Number 1, to prepare and record title curative documents. Number 2, for seller not attending the closing in person. And 3, pay off the proceeds, handling and delivery. Items paid by buyer at closing, buyer shall pay Georgia property transfer tax, the cost to search the title and tax records and prepare the limited warranty deed, all of other cost, fees, and charges to close this transaction except as otherwise provided herein, and all other title fees and post-closing fees. And prorations, the last letter, ad valorem property taxes, community association fees, solid waste and governmental fees, and utility bills, which service cannot be terminated as of the date of closing, shall be prorated as of the date of closing, notwithstanding any provisions to the contrary. In the event of valorem property taxes are based upon an estimated tax bill or tax bill under appeal, buyer and seller shall, upon the issuance of actual tax bill or the appeal being resolved, promptly make such financial adjustments. So there are prorations when it comes to closing costs directed or regarding the taxes. So this is something that needs to be adjusted at the time of closing. And obviously the buyer has to pay his part. We move over to box number 4, closing date and possession. This part is very important, obviously, because it states the date of the closing date shall be. This is where the buyer selects a date of closing. And then we get some options down here. If the possession of the property is going to be upon closing or days after closing at the time, AM or PM. And then if this is the case, then an F-219 form, which is a temporary occupancy agreement, has to be filled out. So everybody agrees to the possession of the property by the seller after closing and any other terms. So normally this normal transaction will be closed upon will be selected the date, and we would select upon closing, meaning that the property is going to be handed to the buyer after closing. Number 5, we get the closing law firm, which is the place where the closing is going to be held at. The buyer is the one to select the attorney that they choose to. Sometimes in the listing, the seller chooses to close with a certain attorney since, you know, they might have the documents or, you know, work started already on the home. That is not mandatory. So know that your buyer can select the attorney that they choose to. So if this is a property that is maybe in a different area, that it's not the area where you work, and the attorney that you work, you know, does not work in that area, is too far, maybe using the seller's attorney can help. And then this is where you would put the company name or the law firm name and the phone number, which is very important. Do not leave any spaces empty. Holder of the earnest money, and this section is important to clarify. If holder is closing attorney, then there's a form, the F-510, that needs to be filled out, is an exhibit, and it needs to be attached to the contract, to this offer, and sent over as part of the offer, meaning that the person holding the earnest money, in this case being the closing attorney, is going to be placed here. And this is where the name of the law firm, the attorney, is going to go. And you need to attach the F-510 with it. And like on the other points, there's a description for each number. Excuse me. Number 4, closing date and possession, the right to extend the closing date. All of this is determined in the beginning if it helps, or if it's possible. Determine if there's going to be an extension, or if the seller needs to be in the home after closing, or if the buyer needs to be in the home before closing, etc. There are forms that need to be filled out. So everybody has a right to extend. Right to extend the closing date. Buyer or seller may unilaterally extend the closing date for 8 days upon notice to the other party given prior to or on the date of closing. Seller cannot satisfy valid title objection. So these are just examples of what could happen. And let's say the buyer needs more time, you may exercise the right to use a unilaterally extension, and it's a contract that it's filled out and signed by the buyer, and it does not have to be signed by the seller, and it gives the buyer 8 days from the proposed closing date to close. And keys and openers at closing, seller shall provide buyer with all keys, door openers, codes, and similar equipment pertaining to the property. So this is part of the contract too. It is added here because the seller needs to provide keys and garage doors, openers, and anything that opens doors in the property. He needs to provide all of that. and needs to be brought at the closing table. Number 5, closing law firm buyers shall have the right to select the closing attorney to close a transaction. Like I mentioned before, that it's the buyer that selects the closing attorney. It comes as part of the offer and hereby selects the closing attorney referenced herein. In all cases where an individual closing attorney is named in the agreement, but the closing attorney is employed or an owner, shareholder, or member in law firm, the law firm shall be deemed to be closing attorney. So the attorney cannot be related to the transaction. This closing attorney shall represent the mortgage lender in any transaction in which the buyer obtains a mortgage. So remember that the closing attorney represents the mortgage company in the transaction. Other than those services specifically listed above, nothing herein shall obligate the closing attorney to perform other legal services, including but not limited to certifying or warranting title of the property for the buyer, except pursuant to a separate engagement agreement signed by the closing attorney and the buyer. Number 6, holder of the earnest money. This is the person who's going to be holding the deposit. The earnest money will be paid to the holder in the method of the payment acceptable to the holder, meaning maybe they required it to be by check or by wire transfer, depending on the person who's holding it. Holder has the right to change buyer for any has a right to charge buyer for any cost associated with the receiving of the earnest money. Such charge shall be collected separately from the payment of earnest money. So if there is any fee for holding that money, the buyer has to pay it. The earnest money will be deposited into the holder's escrow trust account, with holder being permitted or to retain interest if the account is interest bearing. Not later than 5 banking days after binding agreement. So this is also selected in that section in how many days the holder and how many days the earnest money has to be deposited after the binding contract. So after everybody has signed the contract because it's accepted, how many days after does the buyer have to submit or to transfer that money? And it is also selected there. Buyer shall have 3 banking days from the date of receiving the notice to cure the default. If the buyer does not do so, seller may within 7 days thereafter terminate this agreement upon notice to buyer. If seller fails to terminate the agreement timely, seller's right to terminate based on the default shall be waived. And we move over to box number 7, which is the earnest money. Like I mentioned, how it's going to be transferred. Earnest money shall be paid by form of check, ACH, cash, or wire transfer. So in most law firms, some attorneys do not accept cash, and they may accept most commonly checks or wire transfers or ACH. And then we get 3 options, which is an amount. We can select an amount, let's say $3,000 as of the offer date, meaning that within the offer, the earnest money is ready to be turned in. Option B, and it's an amount within blank days of the binding agreement. So there's a difference here. As of the offer date, meaning the date that the offer is submitted, and after the binding date, which means after all the parties have signed the contract. And C for any other options. Number 7, we get quite a lot of information here. We should take the time to read every detail, since it's very important for us to know the terms and the terms about submitting an earnest money. We have here A, B, C, and D, which is entitlement to the earnest money, disbursement of the earnest money, interpleader, and hold harmless. Subject to, on letter A, we find entitlement of the earnest money. Subject to the paragraph below, buyer shall be entitled to the earnest money upon the number one, failure of the parties to enter into a binding agreement. Number two, failure of the unexpired contingency or condition to which this agreement is subject to. Number three, termination of this agreement due to the default of the seller. Number four, termination of this agreement in accordance with a specific right to closing, or if other funds are used to pay the purchase price, then the earnest money shall be returned. So we have to be very careful to protect this earnest money for representing the buyer, and only on these circumstances. Disbursement of the earnest money, holder shall disburse the earnest money upon the closing of the property, the subsequent written agreement of the buyer and seller, an order of court or arbitrator having jurisdiction over any dispute involving the earnest money. Failure of the parties to enter into a binding agreement. Days notice stating to whom and why the disbursement will be moved. Or the failure of the parties to enter into a binding agreement, like going back a little bit here. In addition, holder may disburse the earnest money upon a reasonable interpretation of the agreement, provided that the holder first gives all parties at least 10 days notice stating to whom and why the disbursement will be made. Interpleader, if any earnest money disputes cannot be resolved after a reasonable time, holder may interplead the earnest money into a court of competent jurisdiction if holder is unsure who is entitled to the earnest money. Hold harmless, all parties hereby covenant and agree to indemnify and hold holder harmless from any against all claims, injuries, suits, and damages arising out of the performance by the holder of its duties, including claims caused in whole or in part by the negligence of the holder. Not to sue holder for any decisions of the holder to disburse earnest money in accordance with this agreement. So it's this situation is very delicate, and we have to really be careful on how an earnest money is dispersed. If a transaction is terminated, we have to check dates and contingencies in our exhibits to see if our buyer is entitled to receive their earnest money back, or if the seller is the one who will be receiving the earnest money in case the transaction ends. Number 8, we see inspections and due diligence, lead-based paint. Number 9, inspections and due diligence, we get A and B, due diligence period. This is the period to which we may choose to have a certain amount of days to perform our home inspections and any other inspections done to the property. We may select anywhere from 3 to 7 days to 9 days. This depends on the client and depends on the circumstances. If the time is needed, select as much time as possible, but not too much that the seller is going to reject it. So maybe a standard number of days could be 7 days or 5 days for due diligence. It really depends on the situation. If the home needs a home inspection, needs other inspections, it is best to have the amount of days necessary to perform those things. B, option payment or due diligence period. This is a new section. Number 1, has paid seller $10 in non-refundable option money. The receipt to sufficiency which is hereby acknowledged, plus shall pay directly to seller additional option money of blank by check. Immediately available funds, either blank as the offer date or within blank days from the binding date agreement. Additional option money may be paid to the seller by the seller to the seller, subject to lender approval, or shall not be applied towards the purchase of price of the closing. So this is any additional option money that's selected from the buyer to pay the seller. It is placed in this section right here. And remember to additional to select any of these that apply to the selection that you have made. And number 9, we have the lead-based paint. This is only for properties, we all know this is only for properties that are built before 1978. If the house is built before 1978, then we will need to have an exhibit written down, and it's the F316 lead-based paint exhibit if the house was or was not built. So we select either one. If the house was not built prior to 1978, then we select here. If it was, then it's here, and we need this form. This form is provided by the listing agent, and we cannot do it ourselves. This has to be filled out by the listing agent and the seller, and once we get that document, we get it signed, but it is also part of this offer, since we have that information to begin with. Inspections and due diligence, here's the explanation for that section. Buyer's right to inspect property, buyer's right to inspect neighborhood, buyer's inspection right to continue through closing, buyer's inspection indemnification obligations. Buyer agrees to hold the seller and all brokers harmless from all claims, injuries, and damages related to exercise of the above inspection right by the buyer and buyer's representatives. So this is very important to keep in mind the terms of the inspection during the due diligence period. We get our lead-based paint hazardous evaluation. If any portion of the property was built prior to 1978, then, like I said, we have to fill out this form F316 and have it attached to this contract. Letter F, due diligence period. If the property is being sold subject to a due diligence period, then this agreement shall be an option contract, during which time buyer shall have the option for any reason or for no reason to terminate this agreement upon notice. So due diligence period gives us that opportunity to end the contract without losing our earnest money deposit. Letter G, seller's duty to disclose. Seller shall disclose to buyer any and all known latent or hidden defects in the property that could not be discovered by the buyers during a reasonable, careful inspection to the property. So the seller has the obligation, the duty to disclose anything that may happen to the property that might not be visible during an inspection or by the buyer looking at the house. Warranty, letter H, warranty transfer. Seller agrees to transfer to buyer at closing subject to buyer's acceptance thereof. Seller's interest, if any existing Manufacturer's warranty, service contracts, termite treatments, and other repair warranties. So this is added to the contract that if the house has any type of warranty on the property, performed by the seller or, requested by the seller, then, the seller will be transferring those warranties. And repairs, all agree upon repairs and replacements shall be performed in a good and workmanlike manner prior to closing unless otherwise agreed to in writing by the buyer and seller. So repairs have to, be processed through an amendment to the contract, and all of them have to be done prior to closing and according to any amendment written and signed by everybody. Number 9, lead based paint. If any portion of the residential dwelling on the property was built 1978, like I mentioned, then the exhibit is filled out. And we move over to box number 10. And this is the brokerage relationship in this transaction. And then we have one for the buyer and for the sellers. Buyer broker is, and this is our company name, the name of our company, which in our case will be La Rosa Realty, Georgia. And we get 4 selections here, 4 options. Number 1, representing buyer as client, working with buyer as customer, acting as a dual agent, acting as a designated agent. And in a normal transaction, we represent the buyer as a client, so we select number 1. In section B, seller's broker is, and the listing agent's brokerage firm name will go here. And then we select, assuming that the seller is representing, the listing agent is representing the seller as a client, then we select this for them. Then we get letter C, material relationship disclosure. This is if buyer and agent are related, and it has to be disclosed here. If there's no relationship here, then we write down none, but we cannot leave it blank. Number 11, limited time limit of the offer. And this is the part where we select the time and date for the expiration of the offer. Meaning if you wrote this, let's say you wrote this offer today at 8 a.m., you may place here a time and date for the contract to be expired if the seller doesn't sign it by a certain time, meaning let's say maybe by tomorrow 8 p.m. and then we put the date here, and the seller has that amount of time from 8 a.m. this morning till the next day at 8 p.m. They have time to sign it. If that time expires, then there needs to be a correction or an amendment. And this is the end of page 1. At the end of page 1, we get the buyer's initial and the seller's initial, which have to be filled out. Again, we get the explanation for the different agency relationships in the transaction, and we give a little description of what each means. B, the brokerage. And C, the disclaimer, which means that is if there is any relation between the buyer and the seller, it has to be disclosed. Let's say I'm an agent and I'm representing my uncle, my father, or my mother. I have to disclose here, buyer is related to agent or agent is related to buyer. Other terms and conditions, we get the time limits of offer, and we discussed this already. We can put a time limit to the offer, and after that time the contract is expired, and if the seller hasn't accepted yet, then the offer is expired, and if they do accept it after it's expired, then it needs to be corrected or an amendment has to be signed in case this contract is signed. See other terms and conditions, notices generally, deliverance of notice when a broker is authorized to accept notice for client. All notices given here under shall be in writing, legible, and signed by the parties giving notice. Delivery of notice. A notice to a party shall be deemed to have been delivered and received upon the earliest of the following to occur: the actual receipt of the written notice by a party in the case of delivery by delivery services when the written notice is delivered. So, I mean, if you are emailing this offer to the listing agent, it is important for you to remember to let them know by giving them a call, send a message, and the listing agent has confirmed to you that they have received this. You can't just send an offer and expect to maybe have them see it. When a broker is authorized to accept notice for clients, except where the broker is acting in a dual agency capacity, the broker and any affiliated licensees of the broker representing a party in a client relation shall be authorized agents of the party for the limited purpose of receiving notice, and such notice of any of them shall for all purposes herein be deemed to be noticed to the party. Default, we get A, B, C, and D. Remedies of the seller, remedies of the buyer, rights of broker, attorney fees. In case of default, remedies of the sellers is in the event this agreement fails to close due to the default of buyer, seller's sole remedy shall be to retain the earnest money as full liquidation damages. Remedies of the buyer in the event this agreement fails to close due to the default of the seller, buyer may either seek the specific performance of this agreement or terminate this agreement upon notice to the seller and holder, in which case all earnest money deposits and other payments buyer has paid towards the purchase of the property shall be returned to the buyer following the procedures. Buyer rights of broker in the event this agreement is terminated or fails to close due to the default of the party hereto, the defaulting party shall pay as liquidated damages to every broker involved in this transaction the commission the broker would have received had the transaction closed. For purposes of determining the amount of liquidated damages to be paid by the defaulting party, all written agreements establish the amount of commission to be paid to any broker involved in this transaction. The liquidated damages reference above, excuse me, the liquidated damages reference above are a reasonable pre-estimate of the broker's actual damages and are not a penalty. Letter D, attorney's fees and any litigation or arbitration arising out of this agreement, including but not limited to breach of contract claims between buyer and seller and commission claims brought to broker, the non-prevailing party shall be liable to pay the prevailing party its reasonable attorney fees and expenses. So attorneys do not work for free, we have to pay. Risk of damages to property. Seller warns that all at the time of closing the property and all its items remaining with the property, if any, in any substantially the same condition, meaning that the property has to be given or turned over to the buyer in the same condition the buyer saw it first. So that is something that has to be done by the seller. At the time of possession, seller shall deliver property clean and free of trash, debris, and personal properties of the seller not identified as remaining with the property. Notwithstanding the above, if the property is destroyed or substantially destroyed prior to closing, seller shall promptly give notice to buyer of the same and provide buyer with whatever information seller has regarding the availability of insurance and the disposition of any insurance claim. Buyer or seller may terminate this agreement without penalty or not later than 14 days from receipt of the above notice. If buyer or sellers do not terminate this agreement, seller shall cause property to be distorted to substantially the same condition as on the offer date. So the way that the buyer side, that's the way that the house has to be turned in at the end or at the closing day. Other provisions: A, condemnation; B, consent to share non-public information; C, duty to cooperate; D, electronic signatures; E, entire agreement modification and assignments is something that we have to look over. F, extension of deadlines. No time deadline under the agreement shall be extended by virtual or failing on a Saturday, Sunday, or federal holiday except for the dates of closing. FERPA affidavit, GAR forms, governing laws and interpretations, no authority to bind. Notice to binding agreement date, objection to binding agreement date, rules for interpreting this agreement. This is very important, and handwritten changes shall control over pre-printed or typed provisions. Exhibits shall control all over the main body of the agreement. Special stipulations shall control over both exhibits and the main body of the agreement. Notwithstanding the above, any amendatory clause in an FHA or VA exhibit shall control over consider inconsistent or conflicting provisions contained in a special stipulation, another exhibit, or the main body of the agreement. And statute of limitations: all claims of any nature whatsoever against a broker or affiliate license, whether asserted in a litigation or arbitration and sounding in breach of contract, must be brought within 2 years of the date or claim cause of action arise. So we do have to take the time to read all of these points carefully just to be able to understand the contract. These are just the main points that we are covering. Number 5, definitions: banking date, binding agreement date, broker, business day, material relationship, just giving a little definitions to some of the terms used here. 6, warning to buyers and sellers: beware of cyber fraud. It's very important to be aware. Limit of brokers' liability: buyers and sellers acknowledge that brokers shall under no circumstances have any liability greater than the amount of the real estate commission paid here under the broker, excluding any commissions amount paid to a cooperating real estate broker, if any. Or if no real estate commission is paid to broker, then the sum of $100 and notwithstanding the above shall have no liability to exceed excess of $100 for any loss of funds as the result of wire or cyber fraud. Number 8, we get our exhibits and addendas. This is where we select the exhibits that are going to be attached to this contract. This is very important to select. There's always going to be our financial exhibit, which we have to select which one applies to this offer. If this is if there's a backup agreement, this one, if the closing attorney is holding the earnest money, we have to select this one, and we put the letter of the exhibit on here. So this is, if this is an FHA loan offer, then we select the FHA and then we place as exhibit A, and then we write the letter here. So anything that applies to this contract, that's what we are going to select and place the letter. Our last section is our buyer's information and our seller's information. When we represent the buyer, we put their name here if it's one. If it's two buyers, then we add their information here. We can add as much information as we would like to share. Always write down the full name, legal name, the buyer's phone number, and email address. You may write down their addresses, but their phone number and email address is the most important one. If the offer is accepted, then the listing agent will be filling out the seller's side. The last portion of this contract, we see the buyer's broker information. This is very important. We have to fill out every single box. We can have a contract pre-filled out, so we don't have to fill it out every time. But every single time we write an offer, it has to be filled out. The seller's section or the seller's broker section, this is done. You could do it for the seller. If you have the information, just write it down. So you write down our firm name, which is La Rosa Realty, Georgia. We have to write it complete. We can't abbreviate or anything. This is where our signature will go, our name, our real estate license number, our license phone number, email address, our membership. We should be part of a membership, so this is where we put the name, our broker's address, which we have to memorize, and it'll be added here. Since we do not use fax, this will probably be the only boxes that will be empty. Our office MLS code and our brokerage license number goes here, and then we sign. So we put the seller's broker information, whatever is provided on the listing, we write it down and we send over for signatures. The binding agreement date, this is super, super important. We cannot forget, this is after the offer has been accepted and you have received this document fully signed, then you put the binding date. So a lot of people ask, who puts the binding agreement date? It's usually the last person to receive the contract fully signed. So if the listing agent signs everything, there's no more signatures needed, they may choose to write down the acceptance agreement, but typically it's done once you receive it signed, then you bind it. And this date is going to probably be a little bit different than the offer date. So it does not have to be on the same date, because maybe the seller signed on the next day or the following day. So the date that the binding, the date that is chosen to put here when the contract goes binding is the date that the moment that you receive the contract fully signed. So that is it for the contract or the offer, the purchase and sales agreement portion. And obviously there are exhibits that are attached to it. In this case, in this case, we are using as an example an FHA loan contingency exhibit. And if this is a loan transaction, and let's say the buyer is using an FHA type loan, then we filled out an exhibit, we put the letter on it, and then we fill it out. We get two sections right here. We get A and B. If this is the first mortgage for the client, then we select this, which is more typical, more common. We select A. We put the loan amount that goes here, and it's blank percent of the purchase price, meaning this is a percentage of the loan amount that the client is going to be receiving. Most people receive 95% or maybe 90%, 80%, depending on their down payment. So Let's pretend this is 95% of the purchase price. The term of the loan, which is typically 30 years. The interest rate, no greater than blank percent per annum. And this is where we put the percentage, let's say, you know, maybe 5%. This information will be extracted from the pre-qualification letter that is given by the lender. So if you don't have the information right away, just contact the lender to give it to you to make sure that you're writing down the exact numbers. The type of rate, if this is a fixed rate or adjustable, it's typically a fixed rate. And the source of loan term, and this is institutional. And that's what we have for this part right here. If this is a second mortgage, then we select this and it's pretty much the same. For the second part of this exhibit is use a particular mortgage lender. This is where the lender's information will go. I've seen this section literally empty. So we do recommend that you write down the lender's name, their email address, and their phone numbers. It's always best to write as much information as possible to be able to contact the lender. Financing contingency, buyer shall have the financing contingency period equal to the number of days set forth in section 3 above to determine if the buyer has the ability to obtain the loan described above. Financing contingency period. So the financing contingency period is basically the amount of time that the bank will need to approve the loan, and this amount of days, and I'm thinking that it is, I do not see it here. It's basically part of the I think they skipped a part. So there will be a section of that you will have the option to write down the amount of days that you need for financial contingency, and you may ask your lender to see how many days can they get it approved. It can be 20 days, 25 days, 29 days, up to 30 days. So always put a good amount of days to have enough time to have the loan approved and your buyer doesn't lose their earnest money. We get here, the next point here is the mandatory clause. This is the part where we just write the amount of the property, and it's not going to exceed that number. It is expressly agreed that notwithstanding any other provisions of this agreement, buyers shall not be obligated to complete the purchase of the property described herein, or to incur any penalty by forfeiting of earnest money deposits or otherwise, unless buyer has been given accordance with HUD FHA requirements, a written statement by the Federal Housing Commission, or a direct endorsement lender setting forth an appraised value of the property of not less than, and this will be the offer amount. So meaning that the house has appraised for that amount and it cannot exceed, or you know, the loan is going to be given for that amount. And this section is just, it's always going to be the same. We're always going to put the price of the house right here. We'll move over to number 13, mortgage insurance premium, and this is the FHA upfront blank percentage, and this has been typically 1.75%. Mortgage insurance premium shall be paid by buyer as follow in full at closing, or added to the loan amount in finance. Is we typically select letter A, in full at closing. If anything is different, your lender should tell you so you can select a different option. When mortgage insurance premiums is paid, buyer is aware that a monthly mortgage insurance premium shall be included to the regular monthly mortgage payments. seller shall pay the following lender fees, tax service fees. So these costs are included or are not, are in addition to any closing. So we put are included. This is the typical answer. Number 19, may be obligated to connect to public sewer. So this is the section of the doing the inspection and the appraisal. And this is just to verify who's paying for any of the utility costs. We select one or the other and put the amount. Usually we don't know the amounts, but it's usually the seller is the one to cover all of these expenses. As required by FHA, both buyer and seller agreed that if public water or public sewer system is available at the street, property must be connected. So blank agrees to pay the cost of said connections not to exceed. So we put we selected this part right here. We put the seller, we write down the seller or buyer to pay in case the utilities are not connected, then the buyer is going to do all the work. And then we select the buyer and we put an amount here. Number 20, certification of truthfulness and completeness. Seller, buyer, and broker certified that the above referenced purchase and sales agreement is true and complete. Number 21, certification of arm's length transaction. Buyer and seller clarified that this is an arm's length transaction as there is no relationship between the buyer and seller. So if this is an arm's length transaction, meaning that there's no relationship between seller and buyer, then we select this one. Or if this is not an arm's length transaction and then we select the reason why, buyers relate to seller or blah, blah, blah. We select any, one or the other. If the property is a condominium unit, this purchase of the property shall be contingent upon the condominium in which the unit is located being eligible for and approved by FHA. In the event the property is not a condominium unit, this paragraph shall not be deemed a part of this exhibit. So this is just in case it's a condominium. And here we see another exhibit, and this is a conventional loan contingency. This is another common type of loan, and it goes kind of similar to the one that we just filled out. We select A or B, being the first mortgage or second mortgage, and we do the same. Loan amount, the term, the interest rate, the type, and the source of loan term. Again, we have to put the mortgage or the lender's information here, their name, company, email, and address. Always write it down. And the length of this financing contingency period, the length of this financial contingency period in section 7 below shall be blank days, and this is the option where we put the amount of dates from the binding agreement to have the entire financing completed and approved. So it can be anywhere from 20 to 30 days if the seller, if the lender wants to close in 20 days, and in 20 days we can add this, or 19 days. Length of the buyer to request a reduction in sales price based upon a low appraisal. And this is just a number of days that the buyer has to negotiate a reduction of the sales price if the appraisal comes back low. So buyer may apply a different loan. A loan denial letter, as the term is defined below, must be for the loan described above. Buyer may also apply for different conventional loans than the loan described above. Number 6, buyer to notify seller of intent to proceed. When it's known, buyer shall promptly notify the seller of any mortgage lenders to whom buyer has sent a notice of intent to proceed. with a loan application and the name of the contact information for the loan originator. Financing contingency, we discussed this already on the other one. And the appraisal contingency, this is just talking about the moment the appraisal is done. There is a contingency for the appraisal to be done. Right, and in addition to buyers, other rights herein, this agreement shall be subject to a following appraisal contingency. Buyer shall cost the lender to select an appraiser to perform. So this is done by the lender. An appraisal on the property, provide seller with a copy of any appraisal that is for less than the purchase price of the property. So if it comes back lower, then a copy to the seller is given. And the last part, seller shall not later than 3 days from the date of an ATSP is delivered to the seller, but not later than 2 days prior to closing. Accept or reject the request to lower the price or seek to negotiate the buyer for a lesser reduction in the sales price at the property than what is reflected in the ATSP. Okay, I'm not sure if this is the last part. And I think, yeah, we did come back to the last part of this contract. Remember, everything has to be filled out. You can always get help from the lender or your broker to help you fill this out, but this is the main information that you have to know before writing these documents or these contracts. So thank you for listening and have a great day.